fix you up, make everything much smoother again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. The connections might be tangled, the power source has lost its spark, but every wire tells a story, and I can mend what's torn apart. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. When the current isn't flowing, when the signals disappear, I'll be here with tools and patience, make the static crystal clear. Every cable, every circuit, every problem that you bring, I'll restore what time has broken, make the whole world sing. So don't you worry about tomorrow, don't you stress about today. I've got maintenance for your troubles, and I'll chase them all away. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. Hey, Daniel, everything's good as new. Hey, Daniel, I'll fix you up for you.
Well, welcome. It is Sunday, and today is our Landlord Tenant Docket. Now, some of these might be old, and some of them will be new. So, but Landlord Tenant stuff goes on during the week. Tomorrow is a holiday, so no court will be in session. That would be Judge Flesher, which I have quite a bit of stuff on Judge Flesher that we can watch and discuss. But let's get this started.
Of what? Oh, yes. Birthday today?
It was on Saturday.
Oh. Hello, everyone. We're about to get right to it here. Thank you for saying good afternoon, but we have a busy afternoon. A short lunch hour. Several people in the waiting room. So we've got William LeBray, Jacqueline W., and Robert Dutka.
Good afternoon, Judge.
Good afternoon, Ms. Bauer. Mr. Dudka,
Hi, Judge.
Ms. Winfrey, good afternoon.
Good afternoon.
Ms. Cousineau and the alleged William LeBray from Edwardsburg.
Oh my gosh.
Good afternoon.
Pleasure indeed.
All right, we have only one defendant who's here in a timely manner. It is 1:15. That would be Ms. Jacqueline Winfrey. And the attorney for Village Manor, Mr. Burkhart, isn't here yet. Mr. LeBray and Mr. Dutka have each got some upcoming cases. And we have to wait. I guess while we're waiting, I can go ahead and find Ms. Winfrey of her rights as a tenant. Are you Jacqueline Winfrey?
Yes.
Your manager, Lisa Cousineau, is here, Lori Cousineau. And their attorney isn't here yet, but you're a defendant in a landlord tenant proceeding. They allege that you're delinquent or behind in your rent. They want you to pay your rent or move, and in such a case, you have certain legal rights. You have the right to have counsel for representation in this matter if you hire one. You always have a right to hire a lawyer. If you cannot afford an attorney, a legal aid attorney may be available to assist you. And you could also seek other legal advice. You have a right to trial by a jury or by the court. If you wish to have a trial by the court, you have to advise the court at this first proceeding, a jury trial, and be prepared to pay the $50 jury demand fee unless the court waives it for your inability to pay it. You have a right to have your case heard here in St. Joseph County where the property is located. If your landlord has asked you to be evicted from a residential property because you haven't paid rent, that is this circumstance, you may be able to get assistance from the Michigan Department of Health and Human Services, a local coordinated entry agency, a housing assessment and resource agency, or if you're a veteran, you may be able to get assistance from the Veterans Association. You do not need a judgment against you to receive the help from the places listed above. Copy of the summons and complaint are sufficient. You may be able to reach an agreement with the landlord by going through community dispute resolution, also known as mediation. And if both parties are agreed to it, the court can set it up. Or you may be able to reach an agreement with the landlord that means the case would be dismissed using what's called a conditional order of dismissal. And if that is the case, we will either assist you in preparing it or have counsel prepare it. So we've got plenty of lawyers, one manager, one defendant, but we don't have the lawyer we need, and we don't have the defendants we need for other cases. So good afternoon, Mr. Mistel. It's nice to see you.
You can respond if you want.
Well, you're welcome. Thank you.
Just mute this for a second.
Mr. Gromer,
Yes, Your Honor. Good afternoon.
I'll let you tie your tie. I wonder why you didn't have one on. As soon as I'll put you in the waiting room and let you tie it. Bob, you remember, Bill, you might as well. Maybe Judge McManus had a rack of clip-on ties inside his bathroom door, and he would reach in the door and clip on a tie before he came into court, slip on his slippers and shuffle into the courtroom. And they come out and he'd take it off.
Yeah.
He also had his robe cut down short like a bat cape because he didn't like the long robe. So his robe just came down just under the bench.
That's true.
Yeah, you can do
That's
that.
true.
So Andy has some tip-on ties, but he wears them well. All right, let's bring Mr. Gromer back in. Got time to put on his tie. Good afternoon. Can you hear me, Attorney Gromer?
Good afternoon, Your Honor. Yes.
Good afternoon. While we're waiting for you to log in, we advised the defendant of her rights as a tenant in a landlord tenant case. The title of the case is Village Manor versus Winfrey. The file number is 25121526. Village Manor's manager is here. Ms. Winfrey is here, and attorney James Gromer is here on behalf of Village Manor. This is a demand for non-payment of rent. Rent was $424 per month and quite delinquent at the time of filing. Mr. Gromer, what's the current status?
Good afternoon, Your Honor. The current status is actually much better than at the time of filing. Ms. Winfrey's made several payments in the month of August. At this time, Your Honor, we have $870 in rent still remaining, $200.50 in court costs and attorney's fees, for a total of $1,070.50, Judge.
Well, that's good news.
Yep.
Ms. Winfrey, you intend to stay here?
Yes. I did want to add, I did contact DHS and I'm waiting for my application to be finalized or done processing. I had contacted a caseworker this morning. She said it's not finalized yet.
All right, well, let's talk about that. The law says that you're entitled to one adjournment of at least 7 days. If there is representation that you had requested emergency housing assistance, you may be entitled to a continuance of 14 days. So let's take a look at the calendar. Of course, that will get us into the next month of September. There'll be another month of rent due on September 1st. Either way, we're going to go into September. So let's see what 2 weeks from today gets us. 1 week is Labor Day, so we won't be here anyway. Mr. Gromer, can you do Monday, September 8th at
Absolutely.
2 p.m.?
Yes, Judge.
All right, we'll continue this. Monday, September 8th. Now, if you pay your rent, there won't even be the need for a hearing, but you owe $1,070 and you might as well just add on $424 to that. So you're going to owe about $1,500 to bring your rent current through the month of September. So my advice is always stay in contact with your manager, let her know what your intentions are, and share this information with the DHS. The law says you don't need a judgment from DHS to get the assistance. However, they have a different view of things, and they often actually want a judgment. But if I do find that they're entitled to a judgment, you would get an additional 10 days from September 8th to either pay the rent or move. So that would take you until September 18th. And hopefully that will be enough money for you to come up with the rest of the rent to pay the balance of August and September. Do you have any questions?
No, sir.
All right, we will revisit this at 2 o'clock on September the 8th. If you've paid it all, we don't need to be here at all. But if you haven't, we'll address it further at that time.
Okay.
All right, I think we're good to go. That's the only Village Manor one for today.
Judge, yes, until I have another one at 2:10.
Oh, 2:10. All right, I'll see you then.
Thank you,
And I'll
Judge.
just let put you in the waiting room till then. I'll see you then. Miss Winfrey.
I'll be
you're
fully
good.
dressed before I get on next time.
Okay, we'll make it work. We were singing the virtues of the clip-on tie that Judge McManus used to wear back in the day. I always slip one of those in your desk.
Yeah,
All
I
right.
took it off for lunch 'cause not to spill, and then it just took me more time. Thanks, Judge.
Yes. Stan, thank you. All right, Ms. Guzman, I'll see you then. All right, now we're out of defendants. Our next matter is Meadow Lane versus Johnson. Mr. LeBray represents Meadow Lane Mobile Home Village. Mr. Dutka, you may be interested in this as well. You represent some mobile home communities. We had a very interesting session at the district judges conference regarding landlord tenant law, specifically as it applies to mobile home parks. The whole focus was mobile homes and the rules that apply and the confusion that there is in the law. And there's still a split in the law. After the session, one of the judges from Livingston County sent her take on it and sent an opinion that she had written. Anyway, as you know, the landscape in mobile home communities is changing as they're all getting purchased by large companies, and the world is changing. All right, let me see what I got. Where's this headline?
The chief is a hill. It should have come up. First. Yep. I'll get careful out there. Who's that?
Good afternoon, Miss Henline. You made it. So I'm glad that
Oh,
you're
you just
here.
don't know the day I've had.
Well, you're here, so very good.
I'm here.
We'll address this in a moment. And here's Miss Bussard.
Okay, that's my other one.
Okay.
Elaine, did you give me Rita Henline's file back? Because I seem to be missing it. All right, well, let's talk to the defendants that we do have. Rita Henline is here and Mary Bussard is here. We are missing our 120 case, which is Ms. Johnson. But I will take them and advise the tenants that we have of their rights under the landlord tenant statute. That's Mr. Dutka's office. All right, Ms. Henline, Ms. Bussard. All right, somebody's got, Rita, I'm gonna mute your phone for a minute. But I think we're getting feedback from her phone. We are. She got two things open. At any rate, you are here on a landlord tenant matter. In each case, it is a demand for payment of rent. No, Ms. Bussard is a termination of tenancy. They simply want you to move. As such, you have certain legal rights. No.
I gave it back to you.
Is it in my tray?
I'll go look.
Might have gotten misplaced. At any rate, while we're looking for Ms. Henline's file, you have a right to have legal counsel. If you can hire one, if you can't afford to pay for one, you may ask for assistance from legal aid, and our representative from legal aid, Megan Bauer, is here with us today. You have a right to have the case heard here in St. Joseph County where the property is located. You have a right to demand a jury trial. That has yet to happen in my tenure as judge, but it might. If you do demand a jury trial, you have to tell me at this first initial hearing or file the written demand within 5 days and be prepared to pay the jury demand fee of $50 unless the judge waives it. If your landlord has asked you to be evicted from a residential property because you haven't paid rent, you may be able to get assistance from the Michigan Department of Health and Human Services, local coordinated entry agency, a housing assessment and resource agency, that's Neighborhood Inc., or if you're a veteran, possibly Veterans Benefit Assistance. You do not need a judgment against you to receive the help from the places listed above. Copy of the summons and complaint in your case are sufficient, allegedly. You may be able to reach an agreement with the landlord by going through mediation. If both parties are interested, the court can help set that up. You may be able to reach an agreement with the landlord. That means the case would get dismissed. All right, I'll keep looking for it. And if that happens, we would file or assist you in filing what's called a conditional order of dismissal. All right, let's talk to Rita Henline. If I could find her file. Ms. Henline went through this last year. This is filed as a demand for non-payment of rent. Ms. Henline called with some concern that she wouldn't be able to get here, and I urged to have her try to Zoom in like she did before, and she was able to do that, so I'm glad that she's here. But I've misplaced her file.
It's frustrating.
Here it is. I found it. All right, this is one of the main things we were discussing at the seminar, whether you could file a non-payment of rent rather than a just cause termination when the person owns the trailer and the company owns the lot. Judge Murphy in Livingston County opined that you cannot. At any rate, other judges have different views of it. So this is filed as a non-payment of rent case when Ms. Henline owns the mobile home and Meadow Lane owns the lot. There is another way to do this, Ms. Henline. It's called a just cause termination. And then there's no option but to move. And as a practical matter, it's very hard because mobile homes are really not very mobile. But Mr. LeBray, what's the status here?
Well, there's been a lot of non-payment, Your Honor. The total amount that the plaintiff alleges to be due, which would include the additional 2 months of lot rent, $50 a month late fees, sewer and water fees, attorney's fees, filing fees, service of process, the whole
Well,
thing.
take the costs out first. Just tell me what rent, late fees, and sewer and water.
$8,269.33.
That's through 6/2/69/33.
That's through the August rent. That's a current number.
Lot rent, water, and sewer, and that is expensive in Three Rivers. And late fees. This happened before, Ms. Headline. You were very far behind in your rent, and they somehow made it work. It almost feels like you haven't paid any rent since then. What's the status here? No, let me unmute your microphone. All right, go ahead.
It started back in 2024 when we made these arrangements, and I didn't have any cash then. I had started working for a different company, and I had to sell my van to pay the first $1,500, which I did. And then in May, I was finally paid for the month of April from this company, and I was able to pay the next $1,500. After that, I never got paid again from this company. When DeMarcus turned 21, of course, his waiver changed and he had to go through Summit Point, which I don't know if you're familiar with them. In Battle Creek, they're a mental health facility that a company that will pay his nursing fees. And the company is loaded with many different people and you never get to talk to the same person twice. I gave them everything they needed. It was very difficult for me because they never taught me how to bill until April, about the 25th of April. And so at that time, that's when I got my first check from them, not until May.
Let me ask this, Mr. LeBray, if you can tell me, when was rent last paid on this lot?
Can you need a file? Can I give you this? I have Lois Holloway. She is the regional manager and she has those kinds of numbers. So if you can wait just a second, she'll check.
I read through those payments and I don't understand any of it.
24, Your Honor.
When? When was rent last paid?
5/17/24.
No payment has been made since then?
No. And when I got involved with social services.
Just a minute, I didn't ask you anything.
Oh, I'm sorry.
I will in a minute. And that was my fear, because this is about a year's worth of unpaid lot rent. Are they correct? You haven't paid any rent in more than a year?
That's correct.
All right. You are, again, in dire straits, like we were last time. You're very close to them. Now, there's still an issue that I haven't made a ruling on it, about whether you can even do this. But let's assume that you can, and I can order that you pay the rent. If you don't pay the rent, they can force you out of your mobile home. And then remove the mobile home from your lot. And we were close to that. You had to know this was coming. You haven't paid any rent. You were a year or more behind, 2 years behind last time, and you got caught up, and now you've paid no rent since last May, and I don't need to know the reasons for it. They don't want to continue this. You've lived in this home for 40 years or more, but you can't just continue to stay there without paying rent. And it's worse than that. You don't pay the utilities, and the park has to pay your sewer and water bill. So do you have any plan of approaching this?
Well, yeah, I was trying to explain that to you. Social services could not help me because they did not send me a legal notice to quit. They just sent me little copies that they hadn't written, and the state wouldn't look at it because it was not a filed notice to quit. It was just a copy, and they couldn't help me.
I have one right here filed June 5th. No, that's in the Johnson case. Let me look in yours. Yeah, yours was filed June 11th.
This year.
Yes.
Okay. And that's what I was waiting for. I've also had no satellite or no internet trying to get through to the state again, and I didn't have a phone either. Yes, I'm struggling. I have COPD, yes. and I'm just dying. Period.
Well, we had this discussion last time around, and I don't really like the outcome, but you can't expect to, now, there's an advantage to filing it this way, whether you can do it lawfully or not. Mr. Duck and I have had this discussion. Meg Bauer's been on it several times. If they file it as a demand for non-payment of rent, you may be able to get emergency housing assistance and you can redeem it. So if you pay $6,000, you get to stay. If they file it as a just cause termination, alleging there are 3 late payments in a 12-month period, there's no option. They just seek termination of the tenancy. You would have 10 days to move and 90 days to sell or remove the mobile home. So the way they filed it, and this happened a lot during COVID, when there was emergency funding available, I allowed these to go through and people got their rent paid. But anyway, the law requires that I adjourn this matter at least 7 days. But next Monday is Labor Day and we won't be here. So you're going to be another month behind in the rent. And we're going to go to September 8th at 2:10. Does that work for you, Mr. LeBray?
I'll make it work, Your Honor. That was September
8th at 2:10. Mr. LeBray, I will send that opinion that I just received. I'll redact some of it, but I'll send you that and you can review it. But I've been inclined to allow these, whether the law allows it or not. And as I said, there's a substantial debate. I've got a couple of very learned briefs, one from the Aaron Cox law firm and one from another law firm that argue that this is allowable. We had a very vigorous discussion of this just last Wednesday at the judges conference. Anyway, what this means for you, Ms. Henline, is 10 days from September 8th, they got to kick you out of your house.
Mhm.
Well, actually, they can not. They can remove your mobile home from the lot. They can't touch any of your personal possessions. The mobile home is yours. They could hire a company to come in and remove the mobile home. It's been there 45 years, and I don't think it's very mobile.
No, you can't move it.
No, so, but again, you can't expect to just stay there without paying any rent. And so I don't know. Ms. Bauer, you have any thought on this?
Judge, I think you hit the nail on the head that they can move the home, the plaintiff, the relief it is requesting is the right to remove the home from the lot. Oh, wait, I'm sorry. Were you asking for my input on the law or on consulting with Ms. Henry?
Consulting with whether there's any benefit of you consulting with this client.
Sorry, I was focused on the legal element there.
Well, as I said, you and I have discussed this a number of times here on the record and maybe even off the record, but
I'm always happy to consult with folks, Judge. Sorry, I didn't mean to cut you.
Well, no offense taken. Ms. Henline, I'm going to put you in a breakout room. You don't need legal advice so much. You need money. And you don't have any money. And they don't wish to keep paying your sewer and water bill. And
They're not.
and they're not. So, well, at some point.
Well, you know, this.
In a just cause termination, Mr. LeBray, you have the authority to shut the utilities off. In a non-payment of rent, you don't. You have to continue to provide the services. But we're considerably behind schedule right now. But I'm going to, Ms. Henline, I'm going to let you speak privately with the attorney from Legal Aid, Megan Bauer, and Mr. LeBray and I will move on to the next case.
If I may add one factor, Your Honor, I checked with the local property manager at Meadow Lane, and she advises, who's here today, and she advises me that the sewer and water, at least to the best of her knowledge, has not been turned off.
Okay,
Oh,
I didn't
yes,
think
it
it was.
is.
I mean, we didn't have anything to do with it and we're not
All right.
aware that it did.
So, Ms. Henline, the sewer and water is turned off?
Yes, it's been turned off. And I was concerned too about, we have a new company that owns it now. And they're doing things totally different.
Well, you're gonna get condemned. The city's gonna kind of condemn your house. You can't live there with no sewer and water.
Well, they've been
And
shutting it off for quite a while. And
it's not they, it's the city of Three Rivers.
no,
But
no, it's
the
not.
landlord is doing it?
Yes, absolutely. And
Well,
the
that
thing is, this manager or whoever, this person is not supposedly at the office. This person is like, lives in the park. And I have so many disconnect
All right,
notices.
Ms. Henline, those are all red herrings. You're not paying your rent. You haven't paid it for a year. So any of those things are side issues, but they can't turn your sewer and water off. But
No, they
I'll let
didn't.
you discuss this with the attorney, and we've got other matters to address. So I'll assign you to the breakout room.
Okay.
And we are behind. I think we're gonna have a default here in a minute, but
I don't think
there's Ms. Bauer.
we should.
There you are. All right, assigned to room 1.
Probably
You should be able to plug into it.
should tell him.
All right, I've got others. Rita, hit the button that says join.
Okay.
Is it open, Meg?
Yep.
All right, I got more to do here. All right, now let's have an assessment of who we have here. That's the Henline case. We'll set that aside. I also have Meadow Lane versus Johnson. And I don't think anyone's here on that case. Is Travis Johnson here? Anyone here on his behalf? All right, in this case, we have service by attachment. This is file number 251513. Let me make a note here. LT, which stands for Landlord Tenant. Lois. The defendants are Travis and Ashley Johnson. This is another non-payment of rent with lot only. The Johnsons are not here and they were not personally served, so I can't do a default. Let's go ahead and put this on the record. Mr. LeBray, what's the arrearage here?
I have a total arrearage of $5,690.21, plus water, bringing it up to, and sewer up to $66.42.35.
And what are the costs?
Included in that number was the filing fee. If I add in the $75 attorney's fees, I come up to $6,717.65.
Well, Lois or other park staff, are these defendants still there?
Yes.
All right, they weren't able to serve.
Oh, I'm sorry. They moved out. I apologize.
They moved out. Mr. Dutka's phone's going off again.
I don't know if you heard that, Your Honor. She
They
said
moved
they've been
out?
gone for 3 months.
Well, I can't do a default because I don't have personal service. So we're stuck with, let's go with that September 8th date. I'm sorry, we go into the next month at 2:15. Expected.
25.
I may be willing to give you immediate possession as of that time if you can establish the defendants have vacated. And, but I can't do a default unless I have personal service. Well, do I have a second mailing? Let's look.
We have another mailing address. We do not know where they went.
No, I don't have a second mailing. All right, let's continue this to September 8th. I'm sorry. I can't do a default today, but I can't. So we'll do it at that time and I may grant immediate position. I'll make a note. All right. Is that it for today?
Those are my two, Your Honor.
All right, thank you. I'll
Thank
see
you very
you.
much.
Thank you. All right, so we have another case set at 1:30, and that is entitled Charles Carr versus Mary Bussard. And that's Mr. Dutkus. And Mary Bussard is here and has been advised of her rights as a tenant. And this is a termination of tenancy action that was served on May 20th. Miss, let me unmute you. You're unmuted. Miss Bussard, what's your position? Miss, let me unmute her. You have to unmute your phone. There you go.
Okay. I didn't know what to do. My boyfriend just died on March 30th, and the landlord knocked on my door and said he wasn't going to be accepting my rent
All
anymore.
right, now, say that again. Who died?
My boyfriend.
Okay.
And I didn't know. I was in shock. I was in grief. And the landlord said he didn't want to take my rent anymore. I thought, what? I haven't even buried my boyfriend. And he said, I thought you had cremated. And I thought, well, I never spoke to my landlord about my personal business. But anyway, I got a notice to go, well, wow. And I'm still trying to get my boyfriend buried. It was a long and difficult journey. I was taking time to do that. I was trying to get through my grief and look for a home at the same time. And it's horrible. But no, I'm looking for another house, another place. There's just nothing out there in our price ranges because, you know, we're low income. And I got some stuff I'm going to take in my storage unit, and I'll be out of there as soon as I can find something. How much longer do I have?
Well, let's talk about that.
Yeah. We got buried in a big cemetery, so that's okay. Yeah.
Well, there's no lease, and he wants the property back.
Right.
And once they file a termination of tenancy, they can't accept rent. Lived there since March without paying any rent. March, April into September. So you've been there for months without paying any rent.
Right.
But they want you to move out so they
Right.
can do something with the property.
Right.
So let me look at this.
Thank you.
V5. Mr. Dutka, I didn't want to go 2 weeks with this. Are you available at 1:35 on Friday, September 5th?
Let's see, Your Honor. What time was that?
1:35?
I can do that.
Ms. Bossard, we're going to continue this for about 10 days to Friday, September 5th at 1:35. You would get 10 days from that day to move or be subject to being evicted. So that would give you until September 15th to move out before you'd be subject to being evicted. If you move out before that day, we don't need to have a hearing. But if you do move, you need to turn in your keys and give your forwarding address in writing within 4 days of your moving.
Okay, 40 address.
But our next hearing, and you'll get a new notice, will be September 5th at 1:35 by Zoom like this.
Okay.
Do you have any questions?
No. I need help. Get a
I'll
hold
see
of
you on,
Okay,
Friday, May 5th. I guess you should plan to move. All right, thanks.
yes. I have been planning, yes, sir.
All right, thank you. All right, now I'm going to take stock for a minute and see who's here. We're a little out of whack on our time schedule. Mr. Dutka has the 135 case. We're well past that. Maybe that is our next case. Let's take a look. Yes, it is. This is a land contract forfeiture matter, and it is got some nuance to it. Let's see who's here. I have an iPhone. She's outdoors. Who are you, ma'am?
I'm Charlotte Marino.
All right, let me give you a name. Your case is coming up.
Yeah, sorry, I'm at work. That's why I'm outside.
All right, I don't believe I have a telephone number here. 41751. Who am I speaking with?
This is Charlotte Marino, and that's not my telephone number.
Okay, I've got you. There's a guy who's here just by phone only, which I don't prefer, but who is that?
Yeah, it's Ekbo Mitchell.
Okay. All right, so let's address Mr. Dutka's matter. This is McDougall Sprocket LLC versus the estate of Melissa Ann Halleck, deceased. Mr. Robert Dutka is here on behalf of Melissa Ann Halleck. Mr. Michael. Excuse me, on behalf of McDougall Sprocket, who is
There we go.
The company owned by Michael Mistel. I'm certainly aware of the background here. Mr. Mistel is a practicing lawyer here for probably 45 years. He was a mentor and great friend to Melissa Halleck, and was selling his office to her on a land contract. Melissa's birthday was Saturday, and she was tragically killed in an automobile accident on her way to work here at the courthouse about a year ago. And in the meantime, this land contract is in limbo. Her sister, Andrea Jimenez, I believe, is her representative of personal representative of her estate. Mr. Dutka, can you enlighten me further?
Yeah, Your Honor, I think, well, there's been no payments made since the case was filed. We calculate as of today's hearing, just principal and interest. The estate or the deceased is behind $16,175. There's, as we noted in the complaint, there's other material breaches of the contract. Those total out to be $5,313.92. So really what's owed is well over $21,000. And I haven't even calculated the court costs and attorney fee, but obviously less than half of the land contract principal has been paid.
Have you had any contact with Miss Jimenez?
No, Your Honor. The only contact has been through Mike's sister, Suzanne Sadler. She's willing to sign, apparently, a quitclaim deed in lieu of forfeiture, which I have given that to Suzanne in order to try to get a signature. That would solve the whole issue. We could take back the building and dismiss this case, but that was not communicated to Suzanne until I think Thursday of last week.
I suspect that's what they wish to do.
I
Obviously,
think so. I think so. You're
Melissa's not going to utilize this office anymore. And, well, I was looking at what I have for service. My inclination, Mr. Dutka, is to continue this to the same date I just gave you, September 5th. Let's say 1:40.
We did get personal service. Bruce Morse did serve her. Yeah,
Well,
but whatever you decide, Your Honor.
I'd rather not do the default at this point. For purposes you may need to know, she's presently working for Mr. Bush. So you can probably contact her through John Bush's office. She's helping John. She's an experienced legal secretary, and John had some need for some help in that area, and she's working to assist him. And so you can find her through Mr. Bush's office. So
okay,
I think you're right. That would solve the problem. I suspect that's what they wish to do anyway. And you're going to be here that day anyway. So
yes.
Let's continue it. And the plus, she's paid more than 50% of the contract price. Even if I do enter the order, they'd have 180 days to redeem it, and then it'd still be in limbo for a long time.
Your Honor, I would disagree. No, principal balance due is like $73,000. It's actually more than the original selling price.
Oh, I thought it was 65,000. Oh,
correct.
Balance due. I had it upside down. I
Yeah.
had 15,000 due. Yeah. So yeah, it's less than 50% of the price. I misread it. All right. I think it's worth the effort to see if you can get that. Mr. Mostel can get his building back, and we'll bring closure to it. If not, I'll sign your order by default, and then you'd have another 90 days to deal with it.
Okay. Sounds good, Your
All
Honor.
right. You and I will both be here 10 days from now. I've told you how to find her. I suspect perhaps you guys can resolve this.
I hope so, Your Honor. I'd like to dismiss it.
All right. Thanks. Mr. Marcel, nice to see you.
Good to see you too, Honor.
All right, thank you. All right, now I got more customers here. Let me remove Mr. Dutka.
Thank you.
All right, let's take stock again and see who we've got. We have Andrew Rognus on behalf of Terry L. Richmond, and that matter is set for 2:15, so we're not there yet. We do have a 145 general civil matter, which we'll take up, and let's see if we've got both parties in that matter. We got behind. We've been setting these matters 5 minutes apart, which may be wistful thinking. Mr. Kuipers, are you here on Oliphant Financial?
I'm here in LVNV Funding versus Charlotte Moreno.
That one.
Charlotte is here.
I'm here, Your Honor.
And who is here on Capital One?
Your Honor, this is Jessica Kelly for the plaintiff in Capital One versus Mr. Iqbal McCall, who I believe is present, and I'd appreciate a breakout room if that's possible before our hearing.
Yes, let me call that case, and then we'll figure out what we're going to do with Mr. Kuipers. All right, Mr. McCall, can you hear me?
Yes, sir.
All right, this is a motion for summary disposition with a pretrial. It's a claim for $6,000 $98.99 plus costs, $6,240.99. Attorney Jessica Kelly is here for the plaintiff. And the defendant is here by phone. I'm going to set up I hope Meg Bauer isn't still in there. I'm going to need to kick her out. I'm going to close that. Takes me 30 seconds. All right, Meg. I need the room back.
Yeah, I'm sorry about that.
Perhaps she can contact you later for more information.
She has. I made sure she had our phone number.
All right, Ms. Henline, I'll see you in 2 weeks.
Okay, thank you.
All right, I'm going to establish a breakout room if I can. If I can. Mr. Gromer is back. All right, Attorney Jessica Kelly and Mr. Iqbal McCall. Mr. McCall, this should put you in there automatically when you're there by telephone. So you're going to speak privately with the attorney that's here on behalf of Capital One.
Thank you, Judge.
Thank you. All right. Let's take up our next matter. This is LVNV funding versus Charlotte Marino. Ms. Marino, can you hear me?
Yes, can you hear me?
Yes.
Sorry about that. I'm at work, so I apologize.
You're fine. Attorney Matthew Kuipers is here for the plaintiff.
Yes, Your Honor. Good afternoon.
This is scheduled as a motion to set aside a default, and I set this for a hearing. Frankly, we've had a number of these with LVNV funding and the Rusin and Varchetti law firm, and they're doing the best they can. But I had some cases with this law firm and this plaintiff where the people were falsely alleged to have been served and they were not. I know at least 2 cases, possibly 3, where there was a sworn service of process and they were not served. This defendant wrote me a letter. I want to start with my name. I received a default in the mail. I received last week. I called the clerk and was told that it shows I was served papers at 488 Florence Road, Constantine, Michigan. I had moved out of that property by November 15, 2024 to a different address. I had changed my address at a post office. There was a mistake. I was never personally served at that address. So let's take a look at the proof of service. Tori Renfro, I think that's the problem server, indicated she had personally served the defendant. There is no 488 Florence Road. The numbers outside of the city have 5 numbers in them. And so and this defendant indicates that she was not there. It's the same process server. I believe she's maybe under state police investigation from Kent County, Judge O'Hara's court. Mr. Kuipers, what can you tell me here?
Your Honor, the only thing I can tell you is that, the proof of service shows that it was served. I understand there may be some issues with the process server. It does give a description of the defendant in the proof of service. And it seems to me that may line up with the defendant's description. Additionally, the address that's listed on the proof of service is the same.
What we believe she was doing was looking people up on Facebook and giving their personal description from their Facebook profiles. And so, Ms. Moreno, would you raise your right hand? You swear or affirm any information you're about to give in this matter will be true to the best of your knowledge and belief?
Yes. Yes, Your Honor.
Did you move out of the Florence Road address in November of 2024?
Yes, sir.
And are presently living and have been since that time at a White Pigeon address?
Yes.
And did a process server ever personally serve you with a notice of this hearing on April 22nd, 2025 at Florence Road?
No, Your Honor.
And was the first you knew of this case when you received the default judgment in the mail?
Yes, that was the first I knew about it, and then I called the clerk.
All right. As a practical matter, this debt is not that big. It's $660.17. Mr. Kuipers, I was greatly offended by these. Mr. Varchetti and Mr. Rusin have been very apologetic, and they wish they'd never associated with this service firm. But it's a huge pain in the neck, because then I don't know whether there's integrity to these services or not. And I believe this defendant. I believe she was not personally served. Now, Ms. Moreno, if I dismiss it, they'll just start over again. And you owe $832.17, they claim. Perhaps this might be the situation where you guys could work something out. I could do a dismissal or set aside the default, and you guys can work out some sort of a repayment agreement. Ms. Moreno, would you be willing to do something like that?
Your Honor, I don't even know what I owe the $800 and some for.
All right, I'm going to set aside default. I'm going to set the matter for a pretrial conference. I guess that's a good point. If you never got served with a lawsuit, you don't even know what it is you supposedly did. They claim that you had an account with Credit One Bank, and we will forward you a copy of the complaint.
I'm sorry, can you repeat that?
I'm going to forward you a copy of the summons and complaint.
Okay.
Your Honor, is the court going to order a defendant to file an answer then, or we're just going to be?
Yes.
Okay.
So, yes, you had never been served with a complaint.
No.
And a default entered, and you got defaulted for something. Once you get this, you have 21 days to answer the complaint, or they'll enter a default.
Okay. And I'll receive that in the mail, Your Honor?
Yes. Then you may contact Mr. Kuipers or his office at LVNV Funding and discuss perhaps settling the case. But all of this is a waste of time because I don't trust the integrity of the service.
Yes.
Understood, Your Honor.
Well, I'm not blaming you or the firm. Your firm has a fine reputation, but this has been not good.
Agreed.
The court finds that, now in order to set aside the default, the court is supposed to find good cause and meritorious defense, but the defendant was never served, so I don't have jurisdiction. Court will forward complaint to defendant. Defendant has 21 days to answer. Set a pretrial. All right, Mr. Kuipers, I think we'll eventually get this matter resolved, but I don't believe she was personally served.
Understood, Your Honor. The court will send out notice for the pretrial after the answer is filed, I assume?
Yep.
Okay. Thank you.
Your Honor, will I be served again by them or no?
No, you're gonna get it by mail from me, so the 21 days is a bit vague, but I'm not gonna make them hire a process server and chase you around. We know where you are. You'll get it. You can then answer it, and then we'll proceed further.
Okay.
All right, thank you.
All right. Thank you, Your Honor.
All right.
Thank you, Judge.
Thank you.
All
Who
right,
is
thank
here on behalf of Oliphant Financial? Is that you, Miss Ellis?
Am I
No.
good to go?
Yes, you're good to go.
All right. Thank you.
All right, let's regroup here and see who we've got. We got more people. Mr. Gomer is back. I got Judy R., Lance Thornton, and I had a discovery subpoena on Oliphant Financial versus Margaret Ragland. And I don't have Margaret Ragland or Oliphant Financial. So maybe something happened.
Your Honor, Attorney Elizabeth Ellison, I'm on that case.
All right, that's you. Yes, that's Aaron Cox case. I just assumed you were LT, but it's a GC case.
Yes.
All right, let's talk about that one. Miss Ellison, thank you for your patience. It was set for 1:45, and I hate to get this far behind, but people are overly optimistic. They set 3 or 4 of these at 1:45, and they always crunch the time. Plus, we set our LTs 5 minutes. It hasn't worked out today. Anyway, these are always too many at 1:45. This is a file number 211920GC. I'll just advise you, your boss did a fine job at the judge conference last week. He was a presenter on the thorny issue of landlord tenant mobile home law. At any rate, Ms. Ragland is not here. There's a summons and complaint. There is a garnishment, and there's a proof of service for their asset discovery. What can you tell me, Ms. Ellison?
Your Honor, she was personally served a copy of this on July the 20th. We've not received any payments. So we were just looking to try to have a creditor's exam. Since she didn't appear today, is it your office's policy to show cause at first?
Yes, we do. Occasionally, I'll do an immediate warrant, but let me make sure she's not here. Looking for a Margaret Ragland. All right, thank you. Bye. All right, she is not there, and she has not been here. I'm gonna defendant to fail to appear, do an order to show cause for defendant's failure to appear. If she fails to appear for the order to show cause, she's subject to a contempt bench warrant, but she was personally served, as you said, on July 20th at Eureka Road, Taylor, Michigan.
That's far. Yeah, that's
Oh,
all.
that's your, so she was served at the Douglas.
Yeah, 700 North Douglas.
All right. All right. We'll give another try to this. Thank you for your patience, but we can't do a discovery here if we don't have the defendant.
Yeah, no worries. Thank you, Your Honor. And we'll just get the date in the mail, correct?
All right, yes.
Perfect. Thank you, Your Honor. Have a good day.
Thank you. All right, let's return to Capital One versus Mac Hall. Jessica Kelly is here. Mr. McCall, is he back?
Mr. McCall is on a phone and I believe may need to be pulled in by the clerk.
It's going to take me 30 seconds. All right, Mr. McCall, can you hear me?
Yes, sir.
All right, we return to file 25833GC Capital One versus McCall. This is set for a summary disposition motion and a pretrial. Attorney Jessica Kelly is here on behalf of the plaintiff and has met with the defendant in a breakout room. Attorney Kelly, what's the status here?
Judge, thank you for the time in the breakout room. The parties do agree that the debt is owed, but they have not been able to come up with a resolution on how that debt will be repaid. So at this point today, we'd like to move forward with our motion for summary disposition.
Mr. McCall, twice this morning, I had the pleasure of trying to explain the theory of summary disposition to lay people. But they filed a brief. There's a court rule that applies in Michigan. It's called 2.116. And there are two sections that generally apply, C9 and C10. And they've cited 2.116I and 2.116C. At any rate, the motion for summary disposition contends that there is no material issue of fact. The debt is owed, and you've not stated any defense to the fact that you owe the debt. According to Attorney Kelly, you acknowledge that you do owe the debt, but are unable to reach a repayment agreement. So they wish me to enter a judgment on their behalf under the theory of summary disposition. The claim, as I stated at the outset, is $6,089.99. I add in costs, it totals $6,240.99. You concur with that, Ms. Kelly?
Yes, thank you.
Mr. McCall, what's your position?
Yeah, I don't have a job since 2 years, more than 2 years, because I have gone on some case with my wife. So I lose my job, business, house, everything. I was in jail. So now we don't have a place to live. I live with my uncle. He pay everything for me, like a food and everything. My mom is handicapped. I can't leave her alone. So I'm trying to go different state to get the job. So right now, I don't have anything. Not
Well,
even
the
place
fact
to live.
that you don't have any money is not a defense to the fact that you owe money. But I understand you're currently not in a position to repay this.
Yeah.
All right. Yes, I remember there was a case in front of Judge Pattison, and it was quite, you lost your business and ended up going to jail, and here we are.
Yeah.
But that is not a defense. I'm going to find by summary disposition that you owe this amount of money. Now, if you don't have any money presently, they can't collect money if you don't have any, but your circumstances could change. You could get a job, you could win the lottery, you could inherit $1 million. I don't know, but I find that you owe $6,098.99, $142 in cost for a total of $6,240. You acknowledge you owe the debt. You have not stated any defense other than the fact that you don't have any money or any ability to pay. Are you still at Jeremy Lane in Constantine?
Yes, sir.
All right, I will send you a copy of this order. The contact information for the law firm, Buckles and Buckles, is on the judgment. Now, let me tell you a couple of things. If you don't have any money, you don't have any money, but this judgment isn't going to go away. You're going to continue to owe this, and it will accrue interest. So I would suggest that you contact the law firm and talk about perhaps reaching some sort of payment agreement, but you weren't able to do that here today because you don't have any money. But I did find that you owe this money by order for summary disposition. Ms. Kelly, anything I should add?
Judge, only we know Mr. McCall is considering moving to find a job, and so we would like to be informed of his whereabouts. If it's possible to include an order that he keep the plaintiff updated on the best address, we would appreciate that.
All right. Yes, Mr. McCall, you are to keep plaintiff apprised of any change of address.
Okay, so where I have to call them or call to the courthouse?
Call them, and that information's on the judgment.
Thank you, Judge.
Okay.
All right, thank you. All right, Ms. Kelly, I'll see you again, I suspect, and good luck. Thank you.
Thank you. You as well.
All right, now that takes care of our general civils, which always clog up the docket in the middle of landlord tenant. Let's return to landlord tenant. We took care of Henline. We have Mr. Rognus's land contract forfeiture. We have Attorney Gromer is back for Village Manor. That was set at 210. Andy is 215, so we'll do that. Mr. Thornton has joined us on a Village Walnut Meadows case. So, Mr. Gromer, welcome back. Let's take up your matter, which is Village Manor versus Hotel. And Felicia Hotel is here. Miss Hotel, can you hear me?
Yes, I can.
All right, let me get all the parties here. Manager is also here. All right, we were here last 10 days ago, actually, August 15th. We had a finding at that time that rent through August was $1,692, $200 in cost, 50 cents for $1,892.50. Mr. Gromer, what's the status here today?
Judge, I have a slightly different total. I have $1,442 in rent and $200.50 in court costs for a total of $1,642.50. I believe it's $50 lower. I'm not sure. My number's different, but I have $1,642.50, Judge.
Maybe she paid something. It was $1,692. Now it's $1,442, which means about.
No, I'm sorry. It's $1,642.50 with costs.
$1,642.
Yes, Judge.
All right, I had $1,692. So All right, 1642 and 250 for 1,642.50.
Thank you.
Ms. Hotel, you were going to try to pay on that. What happened?
Had an appointment this morning with Community Action in Three Rivers, and they're actually helping me out with $1,000.
Very good.
I already called Lori here at Village Manor, and I told her what was going on, and I get a paycheck at the end of the week. I have to pay the remainder of what they're not covering in order for them to pay 1,000. So me and Lori are gonna get that all taken care of Thursday and Friday.
All right, I tell everybody to stay in contact with their manager.
Yes.
This manager has worked at several other complexes and she knows how to deal with these matters. But I'm going to make a finding that you owe $1,642 in rent, $200.50 in court costs, and you would have 10 days from today to pay that. $1,842.
No, Judge, I must have messed. Judge, I definitely messed you up. Then it's $1,442 in rent, $200.50 in court costs and attorney fees, and the total is $1,642.50.
All right, that was what I said. That's $250 less than what I had originally, and you said $50.
Well,
So
I thought you said you had $1,692.50.
I did. That's what was given to me with Mr.
Yeah,
Booker
and now it's
last-
$1,642.50. But okay, I got it.
All right. All right. No, the rent was $1,692, and the court costs were $250. That's what was established on August 15th. Then today you told me it's $1,442. That's $250 less. Felicia, did you pay $250?
Yes, when we had court previously, I made a $250 payment the day before court, and it wasn't added in there yet.
Okay, so it's
all right. That's where the difference is.
Sorry about that, Judge.
Yeah.
1442, 250 for a total of 1,642.50. All right, now I don't have a judgment in here, which I prefer, but Mr. Gromer, I'm going to ask if you would send me a judgment in that amount. 10 days from today is September the 4th. Now, Felicia,
yes,
Ms. Hotel, a new month's rent is due on September 1st.
Yes.
You've worked out some sort of arrangement with your manager. Now, when you're going to get $1,000, that's great. But the only thing that cures this is paying the entire amount. A partial payment will not prevent the writ of eviction.
Right.
And another month's rent will be due on September 1st. But Ms. Cousineau is aware of those things. She's shaking her head. And she's going to work with you to try to get this reconciled. Now, 10 days from today is September 4th. They don't have to evict you on September 4th. They have 56 days from today to ask for the writ of eviction. So there is some room, and then they have 56 more days before they serve it. So she's aware of that. You've got a plan to try to get caught up. If you get $1,000 boost, that certainly is a help. But if you can't pay the entire amount, you could be subject to being evicted.
Okay.
And if you are evicted and you move, you have to turn in your keys and give your forwarding address in writing within 4 days of your moving. Do you understand?
Yes, I do.
All right. And my advice is always stay in contact with your manager. Let her know what your intentions are.
Okay. Thank you so much, Your Honor.
All right. Thank you. Good luck.
Thank you, Judge.
All right. Thank you. We'll see you next time.
Thank you.
All right. Andrew, let's take up your land contract matter.
Thank you, Your Honor.
This is Terry L. Richmond. not our normal Terry Richmond, versus Herman Cox III, Cooks III, and Catherine Nussbaum. We were here August 15th. We had personal service as to Catherine, but attachment service only as to Herman. So I was reluctant to enter a default judgment at that time. So we continued the matter for a second hearing. Once again, neither defendant is here, and I'm prepared to enter the default.
Do you need the figures, Your Honor?
Let me see. You gave me the order. Let's see what I got here. Yes. What do we got?
Okay. From the complaint, I had to bring it forward from June 1st to today's date. It's $18,152.10. And unfortunately, or fortunately, I don't know, that goes up by $162 per week, but that doesn't impact on the existing order. There are unpaid taxes, which go up 1% per month of $1,915.18. There are costs of $214.76. And I didn't know how to handle the insurance. I suggested to Mr. Richmond that he acquire insurance coverage, listing him as lost payee, and then adding that back to the contract balance. There is a redemption, but the redemption amount is going to be $20,282.04.
That's due within 90 days. By default, plaintiffs have paid less than 50%. Are they in the property still?
I believe that she is. They split a long time ago, and that's why the payments were sporadic for so long. I suspect she probably wants to do a new contract with Mr. Richmond after the 90 days are up.
All right. Well, she wasn't here at either time. So I've granted your default in the amounts that you pled. And thank you for your patience.
Thank you, Your Honor.
All right. We had another matter, which was entitled Brewer versus Bainbridge. Neither party is here on that matter, and we've received a dismissal order. And they apparently resolved that. Which brings us to Mr. Thornton and our Walnut Meadows case, which is the last matter we have for today. I thought the defendant was here. Tara Winters, I don't see her. We were here on August 15th. Mr. Lance Thornton was here on behalf of the plaintiffs, and their manager Judy was present, and Tara Winters was present by Zoom. We made a finding that 2496.63 was due and continued the matter. She had indicated she got injured at work and had some other issues. Mr. Thornton provided what I always appreciate, a judgment information form. Looks like some payments have been made. So as of this time, Mr. Thornton, the rent is down to $912, water is $65, and court costs are $184.33. Total rent and costs would be $1,161.33. Is that correct?
That is correct through the end of August, Your Honor.
Judy, I'll call you by your first name because that's all I got. Is she gonna try to pay and get caught up?
I have not heard from her since our last court date.
All right, where did the money come from? This was reduced. Somebody paid something.
She paid it online.
All right. All right, well, this is pretty straightforward. I always trust your numbers. 900 through August. Shows $912. Water is 65. Here's water is expensive, 184.33. And court costs for a total of 1,161.33. Now, one thing people often forget is this is only through August. There's going to be another month's rent due of $725 starting September 1st. But I'm not allowed to add September into this by a ruling of Judge Stutzman. But the order does say the defendant may be liable for money damages if additional rent is owed or there's damage to the property. That encompasses that. But the date for the writ is 10 days from today, which is September 4th. Acceptance of partial payment will not prevent a writ of eviction, and no money judgment is entered this time. Judgment 161331161. The fact that she made a substantial payment perhaps shows promise that this matter will be redeemed. And the defendant will get to stay there. All right, Mr. Thornton, anything else we need to do here?
Oh, Your Honor.
All right, I'll see you soon. Thank you. You're good to go. All right, thanks. All right, as always happens, we get stressed in the middle and we end up getting to the finish line eventually. Ms. Bauer, I don't know if Ms. Henline's going to call you further. She made some representations of lockout stuff, but we'll see where that goes.
Yeah.
But I'll see you Friday, I guess.
Sounds good, Judge. Have a good week.
Thank you. All right, that was sure fun. We're going to take a short recess, and we got a number of thorny landlord or small claims cases coming up.
You'll see next week.
Yep. Now I can see if people are having a hard time with money, but you should always contact your landlord and try to make some kind of arrangement, for payment. Housing is tough out there. It's really hard to find housing. So this next one is out of Judge Simpson's court.
Court does call the case. Jeff Lewis versus Michelle Kresnak.
Daryl Barton appearing on behalf of Jeff and Julie Lewis.
Michelle Kresnak?
I am here.
All right. Okay, this is a termination of tenancy case. And basis for the termination?
They have violated the lease. They have not made any payments since February, and the outstanding balance is $9,851.15.
But there is a lease covering the premises?
That's correct. We'd like to ask to, if need be, leave to amend the complaint to include Noah Brush, who apparently has been living there the whole time, and is just the electricity was, he claims to be the main tenant. The electricity was cut off and they added his name.
Well, we've got a problem here. And the problem relates to the notice to quit. Because the notice to quit is terminate the tenancy, but the claim that you have is basically a rent claim.
It's actually including in the lease. I asked that we had a supplemental judgment on that, but the lease, well, my glasses here.
I don't think that you can do that though.
Okay.
If the claim is for not paying rent, then one would have to file a non-payment of rent
It
action.
says under the lease, the lessee agrees that the lease agrees that the lessee's failure or refusal to perform according to the terms of this lease agreement will allow the lessor's option to terminate this lease and begin eviction proceedings. That's specifically in the lease.
I don't doubt that, but it can't be terminated like that. There are two separate sort of avenues. One being a non-payment of rent, one for others. Non-payment of rent and termination of tenancy as a whole without the option to redeem. When it's a non-payment of rent, part of the remedial measures is that the tenant has the ability to redeem. And so I don't know that I can do much with this case, because along the lines that you're asking me to terminate.
File a 7-day notice to quit.
That's what's going to have to end up happening. I don't think, based upon this, that the court has subject matter jurisdiction over the case for the reasons that you stated. So, and when that happens, the only remedy I have is to dismiss the case. So I'll dismiss this case for lack of subject matter jurisdiction, and then we'll await your arrival back here. And with reference to that other issue, could you see Ms. Weidling? We figured it out on the
other case.
The other thing that talking about the execution.
Yeah.
Okay.
Is there something I need to see her about?
Pardon?
Is there something I need to see?
Yeah. If you talk to Ann, she'll update you on what we found out. Barnes and Barnes versus Contavious Scandrek.
I was speaking for the plaintiff, Your Honor.
And also Christopher Mayo.
Mr. Mayo made representations the last time that he was going to get us paid fully.
Yes. And has not.
He is not. And he's not here, and so I'm going to raise my right.
You solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth.
I do.
Go ahead, sir.
We checked the ledger as recently as about 45 minutes ago, and the number is for rent is $2,335.34. That's 2335.34. $250 in costs for 2585.34.
Judgment to the plaintiff. That is by default for possession. Redemption amount is in the amount requested with the writ issue of 10 days.
And if he pays it within the 10 days, I'll set it aside.
Set it aside. All right.
Thank you, Your Honor.
Thank you, sir. Ridgewood Apartments versus Amy Wisner.
Good afternoon, Your Honor. Mark Schlesinger appearing on behalf of plaintiff.
Hello.
Hello,
Your name?
Amy Weisner.
Okay. And how much is owing on this currently?
Judge, with court costs, there is presently $5,460.87.
And how are we going to get that taken care of?
I'm still waiting to hear back from SER. I talked with Hawk and they are out of funds right now, but they have me on their list. And I'm working with family to try to secure anything and still interviewing for jobs. I lost my job in December. I lost all my income source in December, right when I moved in. So.
All right. So the problem that we're going to have here is I've given the adjournment for the filing of at least a claim that you're seeking assistance. I don't have anything. There's not a dispute at all as to what's owed. So what I'm going to do is I'm going to issue a judgment finding no tribal issue in your hearing. I'll issue a judgment for possession and money in the amount paid for $5,460.87. What I will do, since you're waiting on Hawk and I'm not sure where they are.
What's going on, John?
The normal writ date would be the 23rd. I counsel over the objection of plaintiff. There's no writ until the 30th.
Big ideas. Yeah, the week
Judge,
ends
why-
on the 29th, so.
Judge, why would you assume I would have objected?
You're right. I didn't, but in case you did, I was taking a preemptive step.
Thank you, Your Honor.
Thank you. Thank you.
Judge, we'll submit that.
All right.
Bye-bye.
Bye-bye. Northfield Estates versus Tamara Coppin.
Good afternoon, Your Honor. Rachel Dornbush, Palace Law on behalf of the plaintiff.
Hello, your name?
Tamara Copens.
Tamara Copens. I messed up the whole name, didn't I?
That's okay.
All right. What is plaintiff's claim today in this case?
Your Honor, let me
Oh, this is
verify.
actually her motion to set aside.
That's correct.
All right. And ma'am, what's your basis for setting aside the judgment?
I took a fall on their property and busted my kneecap in half. That was February 2nd, and I lost my job, a great job. I had just been approved. I worked for the Veterans Affairs, and I'm not quite sure I know what set aside means. I have tried to make payment arrangements with them. In fact, I even tried to make some payments, but I'm blocked to make them.
Well,
And
let me stop you there.
sure.
This is the motion to set aside the judgment which you filed.
Okay.
And in order to, I'm not even sure how it got set for a hearing because escrow was not paid or bond wasn't paid on this, but that notwithstanding, there are two things that you have to show me. You have to show me that you have a meritorious defense to their claim for rent. And then the other thing that you have to show me is you have to have some good cause for your failure to appear back on May 23rd of 2025.
Yes, I can.
Okay, so why?
I went to the courthouse, and it was closed in Saline. I'm on the summons, which I've never had before. It said appear to the court address above, and it said Zoom, but that box wasn't checked. I honestly thought that I would go to the courthouse, which I did do, and the judge would be on the screen. That's what I thought. But when I got there, it was shut down.
Yes.
And so then I panicked and I called, and the Northfield Estates told me, nope, you're evicted. And I'm like, what? And then I wrote a letter, and then the lady I was working with said, you got to fill this out. I filled that out. And I had no problem paying some money to an escrow. I didn't know about that. But basically, I've tried to make payment arrangements, but I feel strongly that they should work with me because this is on them. I mean, I didn't have to lose my job and fall. And so they should work with me.
Ma'am, so let's assume I take that as a good cause. You're not disputing that you owe the amount.
I am disputing it in the sense that they should negotiate with me because I lost my job because of their mistake.
In what sense?
Negotiate that I don't have to pay the rent or pay some of it until I get back to work. And then the whole thing, because I literally fell on their property and lost everything.
I understand that, ma'am, but I don't know anything about that as to whether or not it's their fault. I
understand what you're saying, but I've given them all my medical records. They know. That's why I was surprised when I got the summons. Actually, my mom got it, and I'm glad I saw it because she doesn't have a great memory.
Ma'am, I don't know whether it's because of anything that the landlord did that caused the fall. And that would not be before me.
Okay.
So the real question is how are you going to get this judgment paid?
I've offered them
because there's probably more owing now.
Oh, I'm sure that there is.
And Your
How
Honor,
much is owed?
the total that's due at present, Your Honor, is $2,902.32. And Your Honor, if I could just state my position with respect to the motion itself.
Yes.
I don't believe that Ms. Copens has good cause for her failure to appear. She indicated that she went to the courthouse in Saline, which understand the courthouse is closed for renovations. But there's no indication that Ms. Copens then called the court to say, hey, I'm at the courthouse, it's closed, what do I do? Instead, she waited until later that afternoon to email me and say, hey, can we reschedule this? I had responded and said, unfortunately, no, judgment has already entered, so the court case is not going to be rescheduled. And so I don't believe that she's established good cause for her failure to appear. That's number one. Number two, I don't believe that Ms. Copens has established a meritorious defense to the underlying action. Your Honor, whether or not there was an incident on the property, and whether or not Ms. Copens can prove that my client was at fault for said incident, I am not conceding, Your Honor, in any way, shape, or form that they are. I would dispute any claims that they are. However, that is separate and distinct from any obligation that Ms. Copens has to pay rent. which she has not done. And so for those reasons, Your Honor, I would have to request that the court deny her motion and allow the judgment to stand in full force and effect. And at this point, we are well beyond the statutory 10 days that was entered on the original judgment, and would request permission for a plaintiff to submit an order of eviction in this matter.
I would like to respond if possible.
Go ahead.
I'm not an attorney. I lost my cell phone service because I have no money. And I have to go hook up to a McDonald's or something, and I'm using these silly text apps. I got in touch with, I didn't know who to call because the place was closed. And then when I would hook up, I figured it out and I made my calls to the court. I don't know if I emailed them first. And I have had no problem. And I've repeatedly said, do we have to go to court? Can I pay this amount and catch up every month? So it is as if they want my dad's house. My dad was a vet, and it's like they just want it. So I don't even know what notarious means.
If you want to build an app and have no idea how to code or where to start, check out
I don't think there's any doubt in Northfield Estates, but it's not for this court possibly, or it's clearly not, but I don't think they have any doubt of where I fell and why I fell. But I don't even care. I just busted my knee, never been in sports, never had that pain except for babies. And I lost a job at the NFPA.
Okay.
So why can I not make a payment schedule, like $1,000?
That's going to be something that has to be negotiated between the parties.
That's what I tried to do.
Okay. But if they don't agree to it, that means that you guys haven't come to an agreement on it.
Right, but they are now saying they want to evict me and my 83-year-old mom when the house has been in my family for 15, 20 years, and it's been paid every month because I didn't prove that there was a good cause. I didn't go to court. I'm confused.
Asking the court to do something the court can't do.
Which is what?
I can't force them to enter into a payment plan.
Okay.
All right. I am here right now on your motion and have to rule legally on your motion. And I told you at the very beginning 2 things that you needed to show me: your good cause for your failure to appear, as well as a meritorious defense of the claim.
And both, I've done one of those.
You have to show me both of those, and neither of those have you shown me.
I did.
We had gotten a call, and it sometimes does happen. I'm not going to dispute that somebody goes to the wrong courthouse. We get a call, we get something.
You did
that day.
You did
saying, "Ma'am, I don't have a record of that."
I sent it to the court, and you emailed me back.
Ma'am, don't overtalk me.
Sorry.
I'll let you go on. I'll let you tell me anything, but you're going to have to stop over talking.
Okay.
Even if you did, and even if I were to find that that's a reason for not appearing, I don't have a meritorious defense of the rent. I have to have both.
I don't have a lawyer. I wasn't told that, nor do I even know exactly what that means. So bottom line is they want $3,000, or what? How much does she want?
It would be $29,0218, but if you pay $22,3479, that may stop the eviction.
I'm very confused. I talked to this court. I spoke to this court. They emailed me back and said, Judge Simpson has set this aside. You're going to go the 13th. So you're telling me to show you something that
told you that.
I have my phone. I have your emails. I have it from your courthouse. Not maybe not you directly.
I can.
She's been copied.
I've seen the email chain, and there may be some confusion. The 14A4 civil clerk did send an email on June 2nd stating Judge Simpson has granted your motion to set aside default. The motion hearing is scheduled for 6/13/25 at 1 p.m. This will take place in person at the 14A1 District Court and provided the address. Have a great day. Ms. Copens forwarded that email to my firm on June 2nd. I then reached out to the 14A4 clerk and I said, the tenant forwarded our office the below correspondence. I asked for clarification as to whether or not the motion had been granted or if the court had simply granted a hearing on the motion. The civil clerk indicated judge has reviewed the motion and set it for a hearing on 6/13/25 at 1 p.m. And I said, so the motion is granted, is not granted, just set for a hearing. If so, that may need to be clarified with the tenant because I believe that Ms. Copens was under the belief that the judgment had been set aside, not that a motion had been granted or a motion hearing had been granted. I did correspond with Ms. Copens after that and explained to her that no, per my communications with the civil clerk, a motion hearing had been granted only, not that the judgment had been set aside, and that the hearing that was scheduled for today would be before Your Honor to determine if the judgment should be set aside or if the judgment would stand. Ms. Copens responded something along the lines of, I don't understand, I don't know the legalese. I'm going to take it to mean the judgment was set aside.
Ms. Thornbush, were you reading, did they indicate initially that the judgment had been set aside?
The email to Ms. Copens does say the judge has granted your motion and set a motion hearing. So it's a little ambiguous, Your Honor. The document that I believe was provided to Ms. Copens, and I'm looking for the notice to appear, it doesn't indicate hearing for non-payment of rent. It indicates motion hearing. And I'm looking for the attachment.
I'm looking at it now, actually. I'm looking at our notice that would have gone out. All right. All right. So you're having the hearing at this point, ma'am. I have not ruled on it at this very moment. However, I'm telling you, I need two things. And the first thing being that there has to be a meritorious defense. Second thing being, and as I'll just tell you, neither one has been shown to me. So the motion to set aside the default is denied, the judgment will stand. And a writ
So
may issue.
you're saying that they can evict me?
Ma'am, what I'm saying is,
I honestly don't understand.
okay, then I'll tell you this. The judgment that was entered on May 23rd will stand. And in that judgment, if you read the judgment, you have a certain time in which to pay those funds. As I indicated, that amount was $2,234.79.
Okay.
If that is not paid, then the landlord can seek their remedy, which would be an order of eviction, indicating that nothing has been paid on this, and then have you removed from the premises. Yes.
Okay, I have one more question. You were not going retrospective back that I had to pay it by the 23rd of that month. I can pay it today. Is that correct?
Do you have it today?
I can't, I will get it. I've got family and friends. I just wasn't gonna give
If you
$1,000.
get it paid, they would need to, the way this court has ruled, they would need to accept it. So
Is there
if
an
it gets-
appeal? Because is there a way to appeal? And I'm saying that only because I was sent.
The made up term, semi-numismatic. Like the industry created their own term.
Something
Ma'am,
that we're having
ma'am, I cannot give you legal advice. If you want to get legal advice on your rights,
I would like
appeal,
to do that.
then you can go and do that. But my order that your motion is denied stands. Motion denied. Thank you.
Well, I guess you're very welcome. All right.
Court calls the case of River Ridge versus Kaylee Hamill Little. Hello.
Hi,
What's your name?
Kaylee Hamill. It's no longer Hamill Little.
Divorce.
Yes, thankfully.
Don't smile. No,
It's
just
okay.
don't smile. Okay, fine. All right. Okay, what is the claim at this point in this case?
No, Your Honor, $1,748.
All right. And how are you intending on getting that paid?
So I have a couple questions because there were court fees from the last time that were added on after every payment was made. Like we were here March, I think it was.
Okay.
And everything was paid up, and then they added court fees on the following month and then denied a payment. It was really weird. So I'd called, spoke with management about it. There's no longer a manager at that location, so they had to call who's ever overseeing it. And then it took days to get back. So I was very confused. And when they explained it to me, it didn't exactly make sense. So my ledger didn't add up and I'd already paid April's rent. So that ended up showing up late. It was a whole fiasco. And all in that time, I lost my job because of nursing school. So I've been fighting with unemployment.
Got it.
So I literally just had like a court hearing judgment, something along those, I don't know the technical term, yesterday that was canceled because my old job stopped protest. I'm not sure.
So are you telling me you can't pay this amount? I'm sorry, Miss Dornbush, you were going to say something.
Your Honor, yes. At the last court date, Ms. Hamel did raise these issues, and Judge Barr advised her to either call management or to call me to discuss. I don't know if she spoke with management or if her conversation with management took place that she referenced took place before or after the last court date. Your Honor, I can tell you that my client has credited court costs of $174 that were assessed in April. I believe my client's intention was to file suit in April. It looks like they did not. So they have credited those court costs. Ms. Hamel is, though, responsible for the court costs associated with this filing that occurred in May. So the $1,747 does take into account that $174 credit.
Yes, and that makes sense because the total figure given at the June 6th hearing was 1922. So they credited.
Okay, so I can make a payment coming up Friday of $300. But like I said, I'm waiting on unemployment. I don't.
When do you think your unemployment's going to hit, and then they're going to have a retro check to you? But you don't know.
You're more acquainted with the state of Michigan than I am when it comes to that.
Probably not, but
I also am
go ahead.
in the process of the hiring at another hospital that is working with school schedules. So,
all right. Here's what I'm going to do. There's not a tribal issue. I'm going to grant a judgment after a hearing on this matter for that amount of the 1748. What I will do, because they can't wait on that, so you can pay the 300 to them. That's at least going to reduce your balance. Okay, and then if you get your unemployment any retro, then you'll be able to do that. Yes. I will have a writ to issue. It would normally issue on the 23rd over the objection of plaintiff if she's waiting on unemployment and I get it. I will go to the 30th. I'll give her an additional week because if she gets her unemployment, then it's going to be getting them to send that other check. So
right.
You get that. So, all right.
Okay.
That's over plaintiff's objection.
Thank you.
Okay.
So I have until the 30th.
You have until the 30th.
Perfect.
But get the 300
next
right away.
Right.
Okay. But that gives you a little bit of relief.
Okay.
All right. Thank you. Scio Farms versus Derek Wanshan. And Elizabeth Wanshan. Hello.
Hi.
What's your name?
Elizabeth Watson.
Wanshan. Okay. And what is plaintiff's claim in this case? This is also yes, go ahead.
$29.05 and 46 cents.
905.46. All right. And ma'am, how are you intending on getting that paid?
I wanted to ask today if we could pay this full balance at the end of the month, the 27th.
Will you have it by the 27th?
Yes.
All right. So here's what I'll do. No tribal issue after a hearing. I'm going to grant a judgment for possession. Okay.
Okay.
In that 2905.46. You say you'll have it the 27th?
Yeah.
Normal writ date will be the 23rd. I'll indicate no writ till the 27th.
Okay.
That'll give you time to get it paid.
All right.
All right.
Thank
Thank you. Spice Tree Apartments versus Samuel Bishop. Samuel Bishop, there is no response. You had previously been sworn. You may proceed.
Thank you, Your Honor. There's rent to retain of $3,584.74, costs of $169 for a total due of $3,753.74. We're asking for a default possession only judgment with writ to issue after 10 days.
Judgment to the plaintiff by default for possession, redemption amount, any amount requested, writ to issue in 10 days. Spice Tree Apartments versus Stephen Shelton.
Yes, I'm here.
Your name, sir?
Stephen Shelton.
All right, you got him. All right. That's not a phone, is it? I'll need a camera if you can get that. But what is plaintiff's claim?
Rent to retain, I'm sorry, Your Honor, the total with court costs is $2,921.69.
All right. Mr. Shelton, how are you intending on getting that paid?
I'm making a payment later today, and then I'm gonna pay the rest next Friday. So by next Friday, it should be all paid.
So by the 20th?
Yes, correct.
All right. So here's what I'm going to do. I'm going to find no tribal issue after hearing. I'll grant a judgment for possession in the full amount of $29,2169. And that is to be paid by the 23rd, that Monday after that. Okay, so that's your statutory period, but if you get it paid by the 20th, you'll be good. Okay?
Okay, sounds good. Thank you.
Thank you.
All right.
Valley Ranch versus Brandon Kuchar.
Brandon Kutcher, hi.
All right, hello. All right, what is plaintiff's claim?
With costs, Your Honor, $4,676.45.
I'm sorry, give me that number again.
4676.45 cents.
45. All right, sir, how are you intending on getting that paid?
We were trying to get it paid by Wednesday, 2 days ago. We were unable, but we'll be able to make payment in full through the rent payment portal online this weekend. We want to get it paid before Monday. I think then that adds another 100.
Apartments.com gives landlords the tools to manage your rentals with ease. It's like having a whole team.
$100 on Monday, so we'll submit it before Sunday evening.
In any event, you'll have it paid before the 23rd, correct?
Yeah, absolutely. If you have to issue the judgment and then it can be set aside, that's fine. We've had to go through this before. We will have it paid in full before the 23rd.
All right, judgment to the. I'm gonna find no tribal issue after a hearing. There's no dispute as to the amount. Grant a judgment for possession with a writ date of the 23rd, and then get it paid. You'll be all set, and you can negotiate the set aside. All right. Okay.
Thank you very
sir.
much, Ms. Dornbush.
All right. And I think, is that it for you, Ms. Dornbush?
It is indeed, Your Honor.
All right. You have a great weekend.
Thank you. You too.
All right.
Bye-bye.
Arbor Club versus Sadie, is it Kayo Amplifon?
Sade Caillou Ashampong. How are you today?
I'm doing well. How are you?
I'm well today.
All right. And Mr. Katz, what is plaintiff's claim in this case?
Good afternoon, Your Honor. Sidney Katz on behalf of plaintiff. There's currently a balance due, including costs totaling $2,994.2994.
Ma'am, how are you intending on getting that?
I'm currently waiting for a check to clear, so Monday or Tuesday, whenever that check is cleared, and it'll be paid in full.
It'll be paid in full.
Mhm.
So certainly by the 20th, you'll have it paid in full.
Most definitely, yes.
All right. I can do it one of two ways. I can grant you the judgment at this point, counsel, or I can turn it out to the 27th. Which would you prefer?
You know what, Your Honor? I'd rather not have to come back if we don't have to. Usually I'd say I'm just getting killed with these court dates, Your Honor.
I hear you. Me too.
So if we could just do a judgment and
All right.
And
then if it's paid, would you agree to set it aside for her?
if she requests a set aside and lets me know, I will do it.
Okay.
Yes.
We'll do it that way. Finding no tribal issue after hearing judgment to the plaintiff in the amount requested of the $29.94 even. All right.
Great. Thank you so much.
Writ date the 23rd. So get that paid and then you'll be all set.
Yes, thank you.
Thank you.
Thank you, Your Honor.
Court calls the case of Six Trails versus Jordan Oren.
Good afternoon again, Your Honor. Sidney Katz on behalf of plaintiff.
That was nice of you to say close enough, but butchering names all day. Your name?
Jordan Oren.
All right. Well, I said it kind of close.
Yeah, it's close.
All right. All right. What is plaintiff's claim in this case?
Balance including costs totals 3,117. 3,000.
All right, sir. How are you going to get that paid?
So my dad is willing to help with a significant portion, and I actually just started work again at the start of this month. So I will get paid on the 26th of June, and mixed with what my dad is willing to help with, it should be able to cover the full cost by the
27th, Your Honor,
26th.
just to give him a little cushion.
Sure.
All right. So no tribal issue after hearing. I'll grant a judgment to the plaintiff in the total amount of the 3117 and writ date 27th. All right, June 27th. All right.
Okay, sounds good. Thank you, Your Honor.
Thank you. Clerk calls the case, Willow Ridge Apartments versus Angela Schmidt.
Good afternoon again, Your Honor. Sydney Katz on the plaintiff. I think there she is. She's on Zoom.
There she is. Ms. Schmidt.
Hello.
Hello. All right. What is the plaintiff's claim?
Balance including costs, 4311, $4,311.
Ms. Schmidt, when are you going to get that paid?
I was supposed to make a payment by today for $1,000. I tried to go online to make that payment and it wouldn't let me. So I was going to drop it off at the front office, but I wanted to make sure that that was where I should drop it off at prior to me doing so. So I have the $1,000. I'm just waiting to find out what my step is supposed to be. And then the remaining balance by the end of the month.
No, 27th. That'll take it pretty much till the 30th at that point.
Yeah.
27th is fine.
All right. A grant judgment to the plaintiff finding no tribal issue after hearing for the amount of the 4311 and writ the 27th.
All right.
All right.
And then
thank you. Yes, ma'am.
The $1,000, do I just drop it off at the front office then, since I can't do it online? It won't let me do it online?
Whenever, however you pay it, you just have to pay the full amount by the 27th. There's no requirements of any specific amounts by any date. As long as you pay the full amount by the 27th, you're good.
Yeah, no, she's trying to figure out where she takes it because I think the portal's probably shut off for her.
Yeah, the portal's shut off. You probably have to find out when the office is open and drop it off there. Give them a call. Just make sure. Okay.
Okay. And I'm sorry, can I have the total one more time?
4311, $4,311.
Okay. All right. Thank you so much. Have a good
Thank
weekend,
you.
guys.
Have a good weekend.
Thank you.
Willow Ridge Apartments versus Woods Edward.
Edward here, sir.
Is it Edward Woods?
Edward Woods, yes.
Okay, I don't know.
I don't know. We keep on doing it this way, Your Honor. I have no idea. This is the only one. It's like the third time I've seen this.
Yeah, that's what's on the documents
I
too.
know.
Okay.
It's coming
Edward
from us.
Woods. Okay.
Your Honor, we did submit a proposed consent judgment to the court last week.
Yes. All right. And Mr. Woods,
I'm here, sir.
you signed the consent judgment indicating that you're going to pay a total amount of $5,030.
Yes,
Is that
sir.
correct?
Yes.
By the 27th. Do you have any other questions regarding anything on the judgment?
No, sir.
All right. Then I will enter that judgment. Sir, I do have to advise you have 3 business days to think about this judgment. If you believe that there's some legal reason, some confusion on your part, or some right you didn't assert, you'd have to file a motion with the court within that time frame. Doesn't mean that I would grant it, but you'd have that time to think about that judgment. You understand that, sir?
Yes, sir.
All righty. Thank you.
Thank you.
Thank you, Your Honor. Have a good weekend. Your Honor, I was
All
ready.
right. You do the same, sir.
I was ready for that last woman at the 1 o'clock docket or the 12 o'clock docket. I think you need like an MC to call your next cases. It sounded like you were one of the TV judges. Next on Judge Simpson.
You might be right.
Have a good day.
All right. Thank you, sir. Cheryl Barksdale versus Leo Stringa.
Good morning, or good afternoon.
Good afternoon. Who do I have here?
I'm Cheryl Barksdale, my husband Marlon Barksdale.
Hold on.
You're still purchasing your lenses from your optometrist?
What are you doing? Come on.
You just brought him along. he just straggling. All right. This is a termination of tenancy case. I don't have the defendant here. The defendant in custody. All right. There's no requirement that we bring them up. All right. Got it. And you were before Judge Barr. He disclosed that he had previously represented you, I think, on something. It doesn't matter. All right. And this is a termination of tenancy and there was a month-to-month lease. Is that correct?
No, it's a year lease.
Wow. Okay.
Lease violation.
Let's see. And in the notice, what are you claiming is the lease violation?
So in his lease, there is in section R, harassment, annoyance, and of tenants. So I'm getting complaints every week about him.
Gotcha.
And then also, in the lease in.
I'm gonna have to stop you, okay? I'm looking at your notice to quit. Everything else looks like it was done correctly. The notice to quit, however, was not done correctly. That's what gives the court jurisdiction to issue a judgment for you, all right? And I can tell you specifically what's in error on it, and that is that, I don't know, do you have a copy of your notice to quit in front of you?
I have the summons and,
If you go back, because you filed the notice to quit, right?
yes.
Well, anyway, at the very top, it says that your landlord is seeking to recover possession of property pursuant to, and then there are 2 check boxes. You have to put information as to why you're terminating it. So the second check box, which is the other, would be what you'd be describing to me. But, and I usually don't go through this with people, but you have to do that because they have to have notice as to why you're doing it.
Okay.
Follow me?
Mm-hmm.
Okay. And so since you haven't, I hate doing this, but since you haven't filed the proper notice, I don't have jurisdiction to do anything except dismiss the case. Okay. So that's what I'll do, because I lack subject matter jurisdiction, and I will just.
Very interesting. So now I have one that I'm going to play. Hope I don't get struck for it. But usually court cases are not. This is Judge Middleton actually confronts a scammer. Since there seems to be a lot of scamming going around nowadays, I thought this one, I'm going to throw this one in before I end for today.
This is People versus Daniel Zerenge. Is that how you say it?
Zerang.
Zerang. Zeringue. Zerang. You're charged with retail fraud in the first degree as a habitual offender. Retail fraud in the first degree is a felony. It's punishable by up to 5 years imprisonment and a fine of up to $10,000 or 3 times the value of the property. You're charged as a third offender, making it potentially punishable by up to 10 years imprisonment. Chief Assistant Prosecuting Attorney Joshua Robert is here, and he has agreed to dismiss the felony charge for a plea to a misdemeanor charge of retail fraud in the second degree. Is that correct, Mr. Robert?
That's correct.
Retail fraud second degree is a misdemeanor. It's punishable by up to a year in jail and a fine of up to $1,000. Mr. Robert, is that your understanding?
Yes.
I mean, Mr. Gibson?
Yes, Your Honor.
Okay. All right, Mr. Zering, you've signed an advice of rights agreement, and you've heard me read them several times this morning, or at least recite them. You'll be giving up your right to have a trial in front of a judge or jury. Understand?
Yes, Your Honor.
I also represented to you that I won't do the sentence here today, and after looking at the affidavit, I think that's the way to go. I think this case needs a pre-sentence investigation report. Anyway, the allegation is that the Sturgis Walmart store had gotten information from the Warsaw, Indiana Walmart store that you'd been stealing from their store. And you were wanted for several Walmart thefts. So they reviewed a video from you being in the store on June 28th. Wait a minute. June 11th. And according to this is an interesting scheme I haven't seen before. You walked around the store with an empty cart, put items in it, went to the self-checkout lane, scanned the mobile app. An employee comes over and checks the items in the bag, and then you let the payment screen time out, and then didn't make any payment, and then walked out with $1,108.64 worth of stuff. Did that happen on August 1st?
Yeah.
All right, you walked out of the store with $1,100 worth of merchandise that you did not pay for?
Yeah.
All right. Do you have charges pending in other jurisdictions?
Yeah, I do, Your Honor.
Where are they?
Huntington County, Kosciuszko County, Elkhart County, Allen County.
Huntington, Allen County, which is Fort Wayne, Kosciuszko, Elkhart. It's 4 Indiana counties. Any Michigan counties? When's your next court date?
I've got one tomorrow in Elkhart. I got one on the 12th in Huntington.
My fear is once you go back to Indiana, I'm going to lose you because one of these jurisdictions got to put you in jail. But I don't want to just shoot from the hip and do the sentence. You're not very repentant. You barely acknowledge doing this, but you walked out of the store with over $1,000 worth of stuff, and you had priors for this and priors at other jurisdictions. Was that how this worked? You'd start the purchase and then let the thing time out?
Mm-hmm.
All right, well, how did it work?
Well, I mean, I'm trying to accept the plea for sake of easeability here, but
All right, I'll accept your plea. How about if I just give you 365 days in jail right now? Why don't you tell me what happened? If you're gonna plead guilty to this watered down version of a lucky ass misdemeanor, you wanna tell me what happened?
I paid for the items.
Get him.
And I paid for the items here, and I believe that the Warsaw detective is who called up here saying that I didn't, and so, but despite me paying for it, I can't get into my bank accounts because I just did 8 months in jail, so I can't access none of my bank. I lost my cards and everything, and I can't log into nothing. I don't even have the same phone, and
I don't believe you. I don't believe that you paid $1,108.64 for this stuff that you came all the way from Milford to Sturgis to purchase. I just want you to admit that you stole this property. I'm not sure why if you don't wish to, that's okay too. Prosecutor will revoke the plea and go back to a felony charge.
yeah, yes, I stole the property.
All right.
So,
What's your employment?
I'm supposed to start at a company called Iodine. I was supposed to start tomorrow. It's in Warsaw.
What kind of work have you done?
I've done a little bit of everything. I've done RV manufacturing, different factories, just random stuff.
Where did you last work?
My last job, I was doing construction.
Do you have an addiction? Is that what's driving this?
No.
This is the kind of thing I would have probably done an embezzlement treatment group, but I don't know what I'm dealing with here, but I am fearful that once one of these Indiana jurisdictions gets a hold of you, I'm not gonna get you back. But this is a pretty good plea offer. I'm gonna set this for, Paul, I got some dates for you and coming up. Some Mondays.
I know that I've got something on Monday, the 25th at 10:30.
That's too soon, I think. How about Monday, September 22nd at 10:30?
That would be good.
Gotta get a pre-sentence report. All right, I don't know what I'm dealing with here. You don't look like methamphetamine or opioids, but it's the kind of behavior that's usually driven by more opioids. And I can't tell what it is you took. Some things that would be taken, which would be easy to sell, electronic equipment, that sort of thing. I don't know if you're taking food or clothing or what the stuff was.
I believe it was a lot of groceries on.
All right. You take this form out to the counter and they'll give you a time and date to come back for the pre-sentence interview.
You're gonna go to the counter and then you'll meet with the probation officer. So.
If you do end up in custody, notify your lawyer or have somebody notify your lawyer so we'll know what the deal is.
Okay, yes, sir.
All right, you're good to go.
Man, I apologize. I didn't mean no disrespect, Your Honor.
Now, I want to say this before I go for today. If I don't have the money for something, I do without. But we also have a service coordinator. So if I don't have any food, I could go to the service coordinator and talk with the service coordinator, and she can make arrangements or try to point me in the right direction to get food. I would never resort to stealing. But that's it for today, ladies and gentlemen. I will see you tomorrow as we talk about Judge Fletcher. I like this guy. He's tough. He's smart. So until then, ta-ta, ciao, ciao. Have a good weekend, what's left of it. I'll see you guys tomorrow at 3:00 p.m. Thank you for watching. And if you're not a subscriber to this channel and you like the content that's on this channel, please consider being a subscriber to this channel. By being a subscriber, you're helping the channel grow and you're helping this platform grow. So I will see you guys tomorrow. You all have a wonderful evening.
Breakdown, you're the one I call from the mountains high.
can't see clear. You're my solid ground, ground, always drawing near. Never give up on this heart of mine. Put it back together every